I'm Ed Parcaut, your host of Inner Edison. What I'd like you to take away from today's show is our greatest growth comes from our greatest failures. Today's guest is Jason Webb. What an easy name today. And let's welcome him and get to know his journey and his story and what does he do. I know you're a patent attorney that deals with that kind of stuff, trademarks, that stuff. But thanks for coming on and talking, because our listeners always have ideas and they need to know how to protect them. And that's why I wanted you on.
Yeah, you bet. Yeah, I do patents and trademarks, copyrights, licensing. What I do is I identify points of fear and vulnerability, and I transform those into hope and opportunity. And I do that by creating protection so that my people can stand out and be at peace while they're executing their vision. So I feel like what I do really lines up really well with what you're talking about. Hey,
before you get into all that, I just want to say that was amazing elevator speech, man. That was amazing what you said there. And the reason I want to key in on this before we go any further is you have to have one, right?
Yeah,
because you have to pull them in with what you do. This is what I'm telling the listeners right now. You have to have what Jason just had. He said what he did, and it brought you in. Just, it's just like people ask me, what do I do? And the question is, do I really want to get into it, or do I say I do mortgage loans, or do I say I help build personal wealth through home ownership? Right? A little different than, it depends on how you want to do it. But what you said is very important. And I'm sorry that I cut you off on your train of thought, but I just thought it was really important to emphasize what you just did there and how people need to have that.
Yeah, and I think half of it is that you want to be able to communicate to other people what it is that you do in a way that draws them in, just like you said. The other half is you want to have a really good idea of what it is that you do, right? I mean, I could say I do patents and trademarks, right? But that's like an activity, right? That's not like a vision. That's, what I do for my clients is I help them be at peace so they can stand out and while they execute their vision, right? It's all about them executing their vision, and this is how I support. And so that's that helps me understand, okay, well, how can I best support?
And that's amazing. So all right, so somebody has an idea of what you want to go through. I'm sure you've been on a few podcasts, you know what I'm talking. So what's the best? All right, I have an idea. How do I protect it?
Yeah. So you definitely want to talk to an intellectual property attorney. So the rules for and the opportunities for protecting whatever it is that you've come up with, they're super complicated. There's a bunch of exceptions to the rules. There's all sorts of things that come into play. And so what you want to do as a business owner or an entrepreneur or a C-level executive is, if you've got something and you're like, this is important to me, I feel a little threatened or a little worried, I want to protect this, I'm not quite sure why, not quite sure how, at that point, go talk to an intellectual property attorney, because they'll help you understand what's protectable, what's not protectable, how to do it, the timing, the costs involved, all those things, right? Because that's just what we do every day. But the fact that it needs to be protected, that comes from you. And sometimes you'll come to an intellectual property attorney and, oh, you can't protect it. Maybe talk to another couple, right? Get a second opinion. There's sometimes really creative things that you can do that maybe not everybody's aware of.
Well, do you have an example?
Yeah. So, it's really difficult to protect clothing, and it's really difficult to protect food, like new menu items, right? But there are some creative things that you can do with branding, where you can't protect the exact cut of the clothing, and you can't protect the exact recipe of the food, but you can protect the things around it. There's also some things you can do with trade secret, right? So there, and of course it's going to depend on the very specifics of what it is that you've created. But if you're talking, a lot of attorneys are very cut and dry, and they always want to be right, and they never want to take any risks. And so they're only going to do the things that always win, and they're only going to suggest the things that are mainstream, typical, regular stuff, right? And so sometimes you need an attorney that is willing to think outside the box, who's gotten education in marketing, who's gotten education in software development, who has enough of a breadth around the area that says, okay, you can't protect this in the normal way, or the normal way won't give you all the protection that you want. So now let's look at these other things and other activities that can dovetail with the intellectual property protection to really get you, some solid protection.
All right, so I have a question. So let's go to clothing. All right, so
Mm-hmm.
I wear a lot of these T-shirts that come from some of these companies that, you know, are all veteran owned and they have this stuff. Can you protect that? Or because you were saying you can't protect clothing, you can't protect the cut of it, but you could protect what's on it, right?
You can protect the branding of the clothing. And
explain that for people to understand what you mean by branding of that.
yeah, so you can protect like the name of the source of the clothing. So like the on a t-shirt, whatever's on the front of the t-shirt is typically just a message. It's just decoration, right? But what's on the tag of the shirt, that's the branding. So the label, right? And I'm not talking about the care and wash instructions. I'm talking about, you know, the label that says who manufactured this, who you're buying it from. You can protect that. Okay. But that said, if you look at the really high-end clothing companies, well, okay, so the mid-level clothing companies, they will put their branding on the front. They'll put their branding all over the clothing, right? And what that does is that sort of melds and mixes the branding with the message. And so if someone were to do, you know, an Old Navy shirt, a copy of an Old Navy shirt, a lot of times it says in big, huge letters, Old Navy right across the front. And so then they could claim that that's trademark infringement. They could stop you from doing that, right? Whereas the really high-end clothing, what they do is they change every year. Every year they've got something new, right? And so what happens is they're selling to a clientele that really want the authentic, the new stuff, the cutting edge fashion. And so they make sure to really protect their branding. They have really clear ways of knowing for their customers, right? And then the people who know those customers, they have really clear ways of knowing what's authentic and what's not. And so then they're able to charge a whole lot more for their clothing than what they otherwise would be able to do. And in 6 months or 3 months or whatever, that clothing's no good anymore because it's not cutting edge anymore. So they've got to then go and buy something else. And so they use that brand protection to make sure that they're able to stay on top of that and able to keep that channel, that funnel of customers coming to them. The red bottom shoes is a great example.
Jimmy Choo's.
What was that?
Jimmy Choo's.
Yeah. So they got a trademark on those high heels with red bottoms, right? And that's a way for you to know that, hey, these are the authentic shoes like this. And so, but they got that protected. And so now that's something that they can go on for years and years and years, 100 years, 200 years, as long as they keep renewing the trademark. They're the only ones that can have red bottom shoes like that. And that's a big deal.
Okay. Yeah, I don't wear them. My wife showed them to me one time, so that's the only reason I know. So
that's okay.
You know,
I've got mine on right now. So
all right. So basically, what you're telling me is the slogans that people have on the front of their T-shirts are just slogans, and you can't protect those, right? Unless
you can't protect that location very well.
No, I'm saying like one I have right now is "I will never quit." They didn't come up with that. That's just something they have on their shirt, right?
Yeah, that's just a message. That's just communication.
So that means anybody could have it on any shirt. Now, if they had that with their logo in there as their brand, that's only those two things together would be protected, but by itself it would not.
Right.
Okay.
Yeah.
All right. I just see a lot of people who come up with these clothing lines and they're like, it's my clothing line because my name's on the side over on the sleeve. Well, that's all you're protecting, right?
Right. Yeah. Yeah. You're not protecting the cut, not protecting the color, not protecting the fabric. You're protecting the branding.
Okay. I got that now. All right. So let's move on to another thing. All right. So let's talk about name protection, right? Actually, let's go through that story you told me about the Washington Redskins. I know they're called something else now, but
yeah, they're the Washington football team.
Wow, amazing name.
Exactly, right. And they even if you look at their domain, so like, you know, the Raiders, it's raiders.com, steelers.com, cowboys.com, but now it's washingtonfootball.com, right? So again, super exciting and easy to type in and nice and short. So here's kind of some background. So they've been fighting with the Redskins issue for a long time now, for more than 20 years, right? People have been saying, oh, it's derogatory, it's racist, it's not okay to do. and they were fighting against it. They even went to court. The federal court said that they had to change the name. Or actually, yeah. So the low level court said they had to change the name. They appealed. The appellate court said, no, you don't have to change the name. And then probably about, I'm trying to remember when it was in the teens. It was, I don't know, like 2014 or something like that. Then the Supreme Court came out and said that you can't deny people trademark rights just because something might be derogatory, right? And that one was the Slants case. So there was a band, a bunch of Asian dudes, and they called themselves the Slants, and they tried to get a trademark on the Slants, and the trademark office said no, because that's racist and derogatory. You can't do that. And they're like, but we want to. And
it's against us.
Yeah,
right?
Exactly. So like, well, how does that make any sense? And so then the Supreme Court came out and said, well, because of free speech, you can't stop someone from having speech, even if it's derogatory, right? That's just, there's not enough of a compelling interest. So at that point, it looked like, hey, Redskins are solid. Nobody can really even come at them again, because that was the way to come at them. So anyway, so last year, then what happened was the sponsors came at them, and the sponsors said, hey, we're really having a problem with this. We really are concerned about sponsoring an organization that people are telling us has a racist name, right? Or a derogatory name. And so the Washington then said, all right, well, we're looking into it. And then 10 days later, they said, all right, we're going to change our name. Okay. And again, it's more than 20 years that they have been dealing with this issue, right? And so when they came out and said, all right, well, we're going to change the name, all of a sudden, what happened is the public realized they're going to change the name. And I'd love to own whatever it is they're going to change the name to. So if you look at the trademark office right now, there are hundreds of trademark applications for Washington Red Wolves, Washington Red-Tailed Hawks, Washington Chiefs, Washington Patriots, Washington Americans, Washington everything. Most of them start with an R. Because I guess that there's a chant that they do that has the initials. And so then they'd want to keep that R, whatever the nickname is, they'd want to keep the R. But anyway, so there's all these people that are speculating on what are they going to change the name to. People have picked up a bunch of domains, right? And so now they have a problem. And I don't know the inner workings of their decision making, and what lawyers are they talking to, or are they not talking to lawyers at all? It almost looks like they're not talking to lawyers at all, which is silly because this is a big deal, right? But yeah, there's tons of people now that have filed trademark applications for football teams, and they don't have football teams. They're just filing these applications in order to try to own whatever it is they think Washington is going to change the name to. And I guess one of the big favorites is Red Wolves, is one that at least the fans are the most excited about. But the Washington Oregon franchise isn't the one that owns that application and isn't the one that owns that domain. And so, it would have been a lot more effective for them to have come up with a name and a plan and got the domain and filed the trademark application before they made the announcement. But it looks like they kind of got caught unawares and just didn't have a plan. So,
right.
Yeah.
I mean, you would think that somebody said, well, if we're going to have to change our name, we're going to change it to this. Let's make it sure that just in case we have to, we have a backup plan.
Right. Yeah.
You would, I mean,
mm-hmm.
That's just amazing, because I mean, that's smart for people to file all those things. So now they have to pay them a lot of money for them, right? If they want to buy it.
Right. Yeah.
Yeah.
I mean, most girls, when they break up with their boyfriend, they've got another one ready to go. Right.
I don't know about that.
It's very
it sounds
simple.
like you're upset about something. It sounds like you have some personal problem.
Not at all. No.
All right. So let's talk. All right. So that's name. So basically, let's talk about protecting. All right. So if I wanted to protect Inner Edison, right? The podcast, right?
Mm-hmm.
That's a trademark, right?
Right.
and I can protect the name, I can protect the logo, I can protect how it's together. There's many different ways you can do it, just like Nike did with the swoosh, the name of Nike and all that stuff, correct?
Mm-hmm.
All right. Should you?
Should you protect? Yeah, so that's a really great question, and not everybody should. So if your business is Bob's Plumbing Supply, and you have one store, right, and it's in your hometown, there's no real and your plan is to keep it that way. There's no reason for you to go spend money on a federal trademark registration. It just doesn't make any sense. You probably aren't even entitled to in the first place. Trademark registrations are really more about people who are doing business in more than one state or intend to do business in more than one state, especially if you're planning on having a nationwide scope to your business, right? Now, so in the example of a podcast like this, right, you'd love to have a worldwide distribution, right? So national is even smaller than what you want, right? But national is what we're talking about. We're talking about, do you want name recognition nationally, and do you want that name to be respected? Do you want people to step off the name and not do things that are confusingly similar? And you want to be able to enforce that. And so that's what trademark registration is all about, is about making sure that nationally you're able to keep people off your name. Right.
Now, I know this question has been out there before. Should an individual own it or a company own the trademark?
So there's not always a super clear answer to that, but you have to have a clear answer to that. When you go and file your trademark application, you have to identify who the owner is. And it is often really difficult later down the road to say, oh, well, I meant this, right? There are certain things that the trademark office won't let you change as the process is going. And the owner is one of those. They'll let you fix like typos, right? So, let's say that, your attorney typed in your last name wrong, right? Did dyslexia, switch the vowels or something like that. That you could get fixed. But if you really wanted it to be owned by your company, but you filed it in your name personally, that can be really hard to fix and even impossible in some situations. And so the answer is, you need to have that clarified before you file the application. That said, sometimes you want it in your name, sometimes you want it in the company's name. If I had to guess, most people, you're going to want it in the name of a company, because you're going to want the protection, the liability protection of the company, because you're going to be doing business under that brand, and you don't want your customers, if things go wrong, you don't want them coming after you personally.
All right. So that's what I was trying to get. So basically, that's why people are sole proprietor. You want to go become an LLC or incorporate. I know that you're not that attorney right now, but I'm just saying you want to protect yourself so that somebody can't come after your assets.
Yeah. Okay. And sole proprietor means they can come after your assets.
Yeah. Because you're the person, if you make a mistake, they're coming after everything you own. I don't care if it's in a trust or not. Well, in California anyway, doesn't matter if it's in trust or not. Yeah. We're not Florida. We're not, some of these other states. Yeah. Texas, Wyoming. I keep going. Yeah. All right. So, because it's important to protect and know if you should protect it, because you could also sell that name, that trademark later, just like we were talking about.
When Fortune 500 companies buy other companies up, they're typically looking for two things. They're looking for brand recognition in a particular demographic or particular group. They're basically looking to buy the relationship that you have with the customers, and the branding and the trademark protects that relationship. They're also looking for user base. A lot of times, especially software companies, they're looking to expand their user base. They're wanting to, collect all, this, 400,000 users that you've got signed up, right? Which in some ways is still sort of a version of that relationship, right? Because it's the contractual relationship as opposed to the emotional, intellectual relationship. It's kind of interesting when you own a trademark. It's almost like you own the little brain cells in everybody's head that stores memories related to that branding. And if you look at the way that the really big companies run their branding and their marketing and their advertising, I mean, think Coca-Cola, right? Coca-Cola doesn't try to teach you a list of all the reasons why Coca-Cola is a better drink, Coca-Cola, especially the most recent advertising in the past like 5 years, it's all about good experiences and fun and happiness. And it's basically saying Coca-Cola is good, you know, and not good as in taste good. Coca-Cola is in good life. Enjoy. I'm a happy person, therefore I should grab a Coke. Right. Yeah. So yeah. And your branding is protecting that.
I mean, that's the new thing that's happened over the last 5 to 10 years is everything's become, it's emotion they're trying to get from you, and they're advertising, not just this is drink a Coke because you're the greatest thing in the world, or you know, it started back when Cindy Crawford was getting that, you know, the Pepsi thing back then when you know, the kid was getting the, anyway. So we'll move on.
Because that's how we make decisions. We make decisions emotionally, and then we rationalize them afterwards. Right. So there's actually there's a study that they did that it may even go further than that. It may be that some of our decisions aren't even made emotionally. They did a study where they had people reach for something and they were checking parts of their brain. And what they found was that the hand started moving towards the thing they were going to choose to reach before the brain activity started. And so they're like, well, if your hand is moving before the brain activity is going, well, what is it that we're choosing? Right. And that's kind of creepy.
Subconscious has control.
Right.
We only use a small portion of our brain. Could you imagine if we could use the whole thing? Anyway.
Well, yeah. And we do use the whole thing. We did the research.
I'm talking consciously being able to use the whole thing.
Yeah. So it's subconscious. Our subconscious mind is extremely powerful and super effective. And so that's why, you know, a lot of times I'll talk to my clients and I'll say, well, my gut says this, and we'll go with what my gut says, because most of the time when we go with what my gut says, then things turn out well. And when we don't, then they don't turn out well. Yeah. So
because your body knows and it's sending blood elsewhere because your gut knows that. So,
right.
Yeah. All right. So trademark patent is an actual idea, right? That's what you're filing when you do a patent.
Yeah. It's technology. So you're getting protection on improved technology.
Right. So and that could be analog technology or digital technology, right?
Yeah. Yeah. So, you know, I one of the fastest patents I ever got for someone was on a pet blanket. It was a blanket that had certain ruffles that were in a certain configuration that were really good at making sure that the extra hair from the pet stayed on the blanket and didn't go around for the rest of the house. Right. And it was useful. It was new. It was non-obvious. It was effective. And so they got a patent on it. I've also got patents on software for doing psychotherapy, right? And also software related to a bunch of other things. So there's all sorts of things you can get patents on, but the idea is it's technology.
So did that pet blanket come out? Did they manufacture it and sell it and all that?
Yeah. They sold it. Mm-hmm. Yep.
I think they need to, is it still in the stores? Because I've never seen it myself.
I'm not sure. I haven't talked to her in a while. This happened when I was a very young attorney. I'm a very old man now. So.
Yeah. Okay. All right. So it's a long time ago. So some other company bought it to put it away, right?
It could be.
Yeah. Could be. Yeah. A lot of those technologies companies used to buy just so they could shelve them and not mess with their company.
You know, I've heard that. I've never been involved in a transaction like that before, though.
Yeah.
So,
well, you're a nice guy. That's the difference. There's a difference. You're not cutthroat. You're a nice guy. You're trying to do what's best for your client, not what's best for other big conglomerates or whatever. It just seems like you're here for the regular person who needs something and needs help. That's what it sounds like.
Most of my clients are entrepreneurs, small, medium-sized companies, and when I deal with Fortune 500 companies, it's usually on the other side of the table. It's either them infringing us or wanting some sort of license that we're wanting to do, something like that. So.
Yeah. All right. So copyright, what are you pretty much? So people don't, I mean, I understand this. I'm just putting it out there.
Yeah, you bet. So copyright's about protecting content, like works of authorship. So
like your book.
Yeah. Your book, videos that you've done, photography that you've done, animation, sculpture, painting, music, all those things, right? Those are all things you protect with copyright. And I'm actually related to the dude who did the first copyright law that we know of in the world.
Wow.
A king in Ireland, And he said, just like the calf belongs to the cow, the book belongs to the person who wrote it. And then 3,000 people died. And then, and I'm not kidding, 3,000 people died because a bunch of people didn't like the law. And then, but they won. And so then the law stuck. So,
wow.
Yeah.
Sounds like today. I'm just kidding.
Yeah. They solved problems in different ways back in 400.
It's all, everything comes around in a circle. Everything comes around. All right. So you're talking about protection of movies and stuff like that, but not now here. But what about these things that people are doing, like on TikTok, some of the stuff like this, they come up with this thing. Can you protect some of those things, or should you protect some of those things?
So they're protected as soon as they're made.
Okay.
The protection is super weak though. And especially when you're on a platform like TikTok, right? That's designed for collaboration, that's designed for, essentially it's designed for people to copy, right? Then you can set permissions, right? People can I don't know what the words are, but people can collaborate with this or not, right? So yeah, they're protected, but there's a huge amount of automatic permission that people are giving each other because they want to work together. But yeah, anytime you put something into a fixed form, so it's a file that you've saved, or it's a paper that you've drawn and written on, it's a sculpture that you've created, a website you've developed, there's automatic copyright protection. But it's really weak protection. And so if it's something you want protected, then you do want to go get a registration with the Copyright Office.
Yeah, because I've heard of a couple of people who have created these huge, platforms, and then some of their students went on there and downloaded all their content and then converted it to their own,
Yeah. A lot of my clients are thought leaders and educators. They teach different things about marketing, about branding, about clothes that you wear, stuff like that. Whatever they're an expert in, right? Then you got to protect your content, because that's people are paying for the content, and it's really easy for someone to just copy it and go start doing the exact same thing you're doing.
And so how can you protect, like, marketing? Everybody, it's been around forever, right? I got my first degree in marketing, got my master's in marketing. I totally understand it. How do you protect, like, say that this is an example. I'm in the mortgage industry. I come up with this whole thing, a whole plan for people, how to get a home all the way through and what they need to do. And they work through this whole thing. How do you protect that so that somebody else can't just copy the same video?
Yeah. So you can't protect the plan itself. So the ideas, the way that our laws are written, the ideas are meant to be free for the most part. Okay. So if I discover a law of nature, I can't get a patent on that, right? If I figure out some cool way to help people get into a mortgage that they couldn't otherwise, I can't own that cool way unless there's technology involved, right? But I can't own that concept, right? If I make a new language, can't really own the meaningfulness of the language. That said, I'm going to teach it my own way, right? So you're going to teach marketing. If you're going to teach marketing, you're going to teach it your way. It's going to be your stories. It's going to be your allegories. It's going to be your way of explaining difficult concepts. And that we can protect, because that's the style, that's the creative aspect of what we're doing.
So basically,
that can be protected.
Whatever I create, how I teach it, that can be protected, but not the actual content of what I'm saying. Correct? Yeah. I'm just trying to understand.
Yeah, it's like they tried to do a big case on a phone book once, saying the phone book was protected by copyright law, right? But that's addresses, that's names, it's facts.
Oh,
right?
Hold on. Listeners, if you're under the age of 25, a phone book that we used to get with people's phone numbers in them, and you'd be able to get it. You watch The Jerk, you'll understand how important the phone books were, because when he was first got his name in the phone book, he got excited. Anyway, move on. Sorry.
Yeah.
We are talking to everybody. Not everybody knows what a phone book is.
That's true. Yep. Yeah.
But it's like things have changed so much, but everything has come back around, right? I mean, the whole marketing stuff. What was new is old, and everything old is new, right? That's basically what we need to focus on. hold on a second. I think I forgot to turn off my Wi-Fi. So it was grabbing it there for a second. So it's important to protect what you can protect so that somebody can't steal it from you, because you put a lot into it, and you know, they don't care if they steal it from you and you didn't protect it. That's easy for them, but it's going to affect you as a person and might get you changed who you are. So please protect as much as possible.
Yeah. And it really changes your business strategy too. There's a lot of business strategies that you can go forward with, and that you have the possibility and option to go forward with if you have protection. And if you don't, you just have to focus on a really narrow set. You know, someone who has no protection at all, they have to drop their margins as low as they can, because, you know, the big companies can come in and outprice them, right? You're not special, so you become a commodity. So you end up, you don't have any leverage in your negotiations. And so you just have to just be as slim and slick and fast and cheap as you can. And that for a lot of products becomes your only strategy. Whereas if you have protection, you can actually do a lot of different things, and you have a lot better margins, and you have a lot better opportunities, and a lot safer opportunities. And you also have the chance of a good exit, right? You know, of building up a company that some other company could do a better job with, and they're willing to pay a lot for it.
We don't know a better job, but you just want to exit, right? That's not insult the
person.
That's
I'm just kidding. What drives the exit, right? It drives
the people are just, I want to see. The big thing that I heard is from most people is build your company to sell it. Don't build your company to love it. It's, you know, it's not your kid, even though most people treat it like a kid, right?
Yeah. Well, and I think you should, I mean, I'll tell you, there is a big difference between someone who's passionate about their business and their chances of success, and someone who is just, who's not passionate about it, who's just trying to turn a dollar, right? Now, someone who's just trying to turn a dollar in a field where they have a ton of experience and a ton of connections and a ton of resources, they're going to do a good job because they've optimized, right? But when you're doing something new, and most of the people that come talk to me, they're doing something that the world has never seen before, right? When you're doing something that's new, when you're bringing something new into the world, that passion makes a huge difference in your chances of success.
And I assume that has to do with like any of the stuff you're doing, right? The blanket you were talking about, the software, all those new things, right?
Yeah, because you're going to run into problems that are completely unexpected. You're going to have to teach people things that they're not ready to learn about. You know, there's all sorts of things where your passion is going to help drive you forward. Now, your point is a good point, that when it comes time, treat it like a business. Don't treat it like a child, right? Have the passion, have the drive, but remember that it's a business. And so when it comes time to make business decisions, make good business decisions.
Well, I mean, the problem that I'm running into, like, I built many mortgage companies, right? And, you know, the exit plan is, do I sell? What do I do? But most of the time it's just, I enjoy what I'm doing. I don't want to get rid of it. It's, you know, success to each person, you know, but eventually I will want to be done. You know, my plan for this one is to sell it to my employees. You know, my last 5 years in the business, sell it to them, let them have it, so they have something to, you know, move on.
And have something that you're excited about to move on to. That's, I think, an important thing. I've noticed that sometimes people really stall the sale of a company if they don't have that next cool thing that they're really excited about, because then they're like, oh, I enjoy this, I have fun. What am I going to do tomorrow if I sell it today? So, yeah.
All right. Anything else? I mean, because you deal with this all the time. This is your passion. You know, what's the first step? Someone just call the, I mean, because what's the cost for a consultation usually?
So most intellectual property attorneys will do initial consult for free. Not all of them, but most. I'll do one for anybody that's a listener of yours. Be glad to do that. And usually it's about a half-hour consult. It's protected under attorney-client privilege, so you can tell them about what you're doing, even if you don't hire them, because otherwise, how could you shop around for attorneys if you couldn't tell them what was going on, right? So you tell them what's going on in your mind, what your plans are, and then talk about, well, what would it look like to protect that? Is it something that can be protected? Is it something that makes sense to be protected? What would the next steps be? What would they cost? That's sort of what the conversation looks like.
Okay. And by the way, so just remember, if you guys are gonna, Jason, how do they get a hold of you? What's the best way?
Yeah, so email is probably the best way. PearsonButler.com is our main website, and then my email address is Jason W, so like Jason Webb, Jason W at PearsonButler.com. Pearson is P-E-A-R like the fruit, S-O-N like the child, and then Butler is spelled like you'd expect Butler to be spelled.
All right. And then just put in there that you heard him on, on Inner Edison, and then you'd like to have a consult with them. And you do all over the nation, right?
Yeah. Intellectual property law is federal. So I'm in Utah, in Salt Lake City, but most of my clients are in California, Texas, Florida, New York. All over, even outside Russia, Mexico. So,
wow. One last question. Do you internationally, if you're protecting it nationally, should you protect it internationally?
If you plan to have customers internationally, then you should definitely be looking at international protection. And some projects, you'll make more money outside the United States than inside the United States, especially if it's without giving away information about my clients' businesses.
In general, is it clothing?
There are some products where the fact that it's American is a big pull to sell it. Right. So sometimes books are that way. Sometimes clothing is that way. Sometimes luxury items are that way. Right. And so the fact that, oh, this is American product, I want to have the cool American product, you can actually sell a lot more outside the United States than you would sell in the United States.
Well, that was like Levi's in the 80s over in Australia. I had Brian Smith on, and he was talking about Uggs, and the person, Ugg was just a normal word over there, right? When he came here, he registered it as soon as he got here, right? And it was his name now. He owned it, and he fought for years, about that registration, and then finally won in the early 90s or late 80s. So it's important to register names and certain things just in case you're going to move forward on something, so you're protected.
Yeah, and because you don't want to find yourself in the horrible situation of you've got a container load of product that's got packaging and it's got the name all over it, and you've got your website and you've been running ads, and then you get a cease and desist letter that your lawyer tells you that you've got to comply with. Right. And then all that money, to repackage things, to rebrand everything. And you've got to do it really fast. And you're losing all the momentum from your marketing. It's just you don't want to find yourself in that position at all. You want to be way ahead of the ball on that. So
basically, talk to Jason ahead of time. Yeah. At least, talk to somebody ahead of time. Make sure that's what your plan is. Make sure whether or not you should protect it, if you should, how to do it, and how long does a trademark usually take?
Usually takes about 6 to 12 months to get the registration, as long as things go smooth.
Can you use it in the meantime?
Yeah. And a lot of times you definitely should be using it in the meantime. You want to be careful about using it before you've done the research. So you typically will do trademark research before you file the application. And if the research looks good, then typically at that point, you go full speed ahead with using it while the application is going through the process.
Is that what the SM service mark means, or next to a name or something like that?
Yeah,
usually?
Kind of. So TM is what you use if you don't have a registration, but you believe that that's your trademark. You believe that you have trademark rights in it. The circle R is the one where you do have a registration. SM is just like TM. It just is service mark instead of trademark. There was a time where people thought it made a big difference or a significant difference between I sell goods or I sell services. And so then they thought, oh, we should have TM for selling goods and SM for selling services. But you can use the TM for selling services too. And people have just really defaulted to the TM. There's not really much of a point of using the SM, and you don't see it very often.
Oh, see, look, learned something new today. All right. And so the R is actually when you actually own it, it's fully registered, right?
Yeah, exactly.
So TM is basically you don't own it, but you think you do because you did the research and it's going through the process.
Yeah, I mean, you may own it. You believe you own it. There's common law rights in trademarks, but just like the common law rights and copyrights, they're not very strong. And if someone has the federal rights, the registration, a lot of times they're going to supersede your rights. And so, you know, it's just, if it really matters to you, get the registration. If it matters to your business, get the registration.
Is that a different, I want to be clear, is that a difference between the trademark and registration? Or are we talking about just finalizing the trademark application and getting it done for the registration?
Yeah. So, I mean, so for example, let's say that you did something and it was a hobby and you had a brand for your hobby and you sold some, right? You would have federal common law trademark rights in that brand without going and getting a registration. They would be only in the geographic areas where you're selling, and they would only be where you were the first one to use a brand like that for those goods and services in that area, right? So it would be really complicated to figure out exactly what rights you had, especially compared to what rights other people would have, but you could have some rights. And if it's just a hobby, then you know, maybe you don't need to get a registration and it's not a big deal. It doesn't really matter. But if this is your business, if this is something you're trying to grow this into something meaningful, and you're being serious about it, then that's where you don't want to rely on the common law rights, because they're fairly weak and they're fluid and they're difficult to understand. You want to have something on the record that says, this is mine, I own it, and the federal government agrees with me, and the federal government is willing to put the might of their laws behind me if I have a struggle with someone. So,
all right. So what I was trying to ask was, the registration means it's final, that you actually own that mark. You own, yes. It's where the TM is going through you say I own it, and you're going through the process of getting it registered.
You finalized. Might be going through the process, might not.
So yeah. You could just put TM on there no matter what, because you think you own it. But
yeah,
it doesn't mean you own it nationally.
Yeah. So as an example, when you get a trademark registration, the trademark registration includes a list of the goods and services that you're selling under that brand, right? And so Harry Potter, for example, right? So Harry Potter, they have federal registrations, I'm sure, right? And they're listing goods and services that they're doing. But let's say that they decided to do tie pins, right? But maybe they don't have a registration on tie pins. So on the packaging, they may put a TM on Harry Potter TM, not the circle R, because they don't have a registration for Harry Potter tie pins. Okay. And they may decide that they don't even want to file an application for it, because that product line it's a short-lived thing. They're going to do it for a year and quit, or maybe they're going to do it and it's just a trickle of money and they don't want to devote energy into getting that registration. Or maybe they do and they have filed an application. No matter what, they're going to start with the TM. And until they have the registration for tie pins, they can't do the circle R.
Gotcha. That's what I was trying to clarify for myself.
Yeah.
Okay. Perfect. All right. So 10 minutes ago, I was like, okay, are we done? I'm just like, that's the one thing about this whole show is, like, sometimes you come across things and you're like, what about this? And then we go past the 30-minute mark, which is exactly what I said. It's, as long as it's interesting, we keep going. And this is interesting because it's important to protect. If you need to protect it, like you said, Bob's Plumbing, you don't need to protect that because there's like 20,000 Bob's Plumbings and probably in the United States, because Bob's a popular name, I guess, in plumbers. All right. Anything else that we should look at, with what you do? Anything else you want to add before we go? I love what I do. I love supporting entrepreneurs and small and medium-sized businesses. I feel like they're the backbone of the economy. I feel like, what we're doing collectively is bringing wealth and abundance and success into our culture, our economy. I love being a part of it. I love having people tell me new things that they're doing. That's why I became a patent attorney, was because I get bored really easy and really quick. And so I love that people bring me cutting edge stuff, and that I've got to get up to speed on it. And so just a lot of fun. It sounds that way. I mean, it takes a unique individual to do patent law.
It does. And you have to be a scientist engineer who wants to go talk to people and read and write. And scientists and engineers don't typically like that at all. So.
Jason, I appreciate you being on today and talking to my people. I appreciate it.
Ed. Thanks for inviting me.
No, it's been a pleasure. Hey, I want to thank you for joining us today on Inner Edison. I hope you enjoyed today's episode and what Jason shared. If you like what we do here, just follow for more. And again, thank you again, Jason.
Thank you.